workshop meeting of Commissioners Court, Grimes County, Texas. We'll call the meeting to order. The agenda item that we want to discuss is review and discuss actions associated with the purchase property at FM 2445 and possible disposal of Stoneham property.
Judge and Commissioners, before you begin on that, I'd like to make some preliminary comments. We're still close to closing.
Yes, sir.
That I reviewed the commitment yesterday or the day before, and after I reviewed the commitment, usually you then begin to consider what the deed's going to look like and the exceptions that are listed in the commitment. This is an insurance policy from a title company, and as insurance companies are wont to do, they'll list as many exceptions to coverage as they can. What your job is, as the buyer, is to try to get rid of as many of those exceptions as you can. So you got more coverage rather than less coverage. So there's some things that trigger concerns for me and some things that don't. But one of the things that I wanted to consider was doing an affidavit of non-production from the current owner, from the sellers, to indicate that there was no activity on the oil and gas leases that were shown in the title commitment. They're old. They're from the 90s, as I recall, maybe in the early 2000s, but I think the 90s. And so I wanted an affidavit from the current seller to say that there had been no activity. The way the oil and gas lease works is there's usually a primary term of oftentimes 3 years. They have to begin producing and paying quantities within 3 years. If they don't, the lease expires. If they do, the lease is alive as long as they're producing and paying quantities. So you want to know from the seller that you're buying from whether there's any production to have kept those leases alive. And if they do an affidavit and swear there's been no production, no activity, they'd have been not been getting a check, then you're pretty confident that those leases expired some time ago, so that there's not going to be any oil and gas activity on your property. So when I analyzed that, I got to thinking about what we wanted to tell the title company we needed to see from the seller. At that point, I learned or relearned, I figured out that CenterPoint had sent us a draft of a proposed deed when we did the contract. For whatever reason, I never saw it. I feel confident that I didn't see it. I should have. Just nobody's fault but mine. Somehow I overlooked it. And so when I found that deed, in that deed is a proposal from them. It's effectively a proposal that they reserve all the minerals and a couple of other things that I'm going to get them to change that I think are non-issues. I called Commissioner Dobianski yesterday to ask whether that was the court's understanding of what this deal is CenterPoint's reserving all minerals. I don't recall having that conversation, and when I drafted the contract and sent it to them in PDF, my recollection was they just executed the PDF that we sent them. Well, apparently they had Adobe Professional, like we have Adobe Professional, where you can tinker with the PDF. And they made some changes to it that I either overlooked or just never saw. And one of them was attaching this deed, this proposed deed. It's not end of the world. The question I need to ask you, and this goes to actions with the property that's being purchased, did you intend to authorize that payment of $400 for property with minerals, or do you care about the minerals being, would you have negotiated a different price, given that this is in the south end where we know it's unlikely that there are any oil plays, maybe gas. I'm going to have I left a message when I discovered this yesterday. It gave me some heartburn for most of the day, and I called the attorney this morning to try to get straight with him about whether those were issues that they were deal breakers to them. And my desire is to find out whether it's deal breakers, whether that is a deal breaker. It's really the reservation. At the very least, I suspect they will agree to a surface waiver that says they reserve the minerals, but they won't use the surface to get at their minerals. Looking at what the title company doesn't insure minerals, okay? So I'm looking at the commitment, and I'm guessing, based upon what I've seen, that the folks who signed oil and gas leases in the 90s or 2000s, whenever it was, were the people that sold to CenterPoint. So I'm guessing that CenterPoint got the minerals. I'm guessing that CenterPoint has the minerals now. If they reserve the minerals, we need a provision from them that says they won't use our surface to get at their minerals.
Right.
That's probably a non-issue because it's a 19-acre tract. This happens all the time, because if the 19-acre tract was ever used for mineral production, it would probably be pooled with many other tracts or several other tracts. Or they could use horizontal drilling to get at the minerals. You don't want to have a well show up. It's a, as Mr. Walker and I were talking about, 5-acre well site show up on your surface when you got a 19-acre tract. So I suspect they'll agree to that. To me, that's not really that big a deal. I can't foresee any pushback on that. What I don't know is whether they'll say, oh yeah, we want the minerals, and if you guys are gonna fight us over the minerals, then we want out of this deal. Now, I've found some other provision in the contract that could get us out without losing our $4,000 in earnest money. Worst case scenario, we draft the contract to say they can't sue us for specific performance. They can't make us go through with the contract. We get to walk away. The question is, do we lose our earnest money? Well, there's a provision that hasn't been met to this point that would allow us to walk away without losing our earnest money. So imagine yourself back in the shoes of the folks who were negotiating this thing on the front end a month ago, whatever it was. Would you say, I will pay this amount for not for the surface rights, not getting the minerals, or by God, I'm not paying this amount unless I get the minerals with it? That's kind of something, and let's talk about, I would suggest we talk about the other issues and come back to circle back to this, and/or any one of you can call, or all of you can call me individually at my office and tell me what you think. I'm not thinking that, it's not set for any action today, so I'm not asking you to take formal action. I just need some guidance on that to know whether that's a deal breaker for the court if we don't get the minerals, because then I can push back and say, look, my fault, didn't see your proposed deed, and my court wants the minerals here, and it is a deal breaker. And if they say, well, I guess that's the deal, then we talk about whether they think they're entitled to our earnest money or not. I've talked long enough. So.
John, did you say you sent them a proposal and then they sent the one back to you?
We drafted the contract, we sent it over to them, and the usual TREC form, Texas Real Estate Commission form, says, and this changed just a couple of years ago, but it says if any party's going to reserve the minerals, that you're going to attach a mineral reservation addendum to your contract that says the party is going to reserve the minerals, and then it has two boxes to check as to whether the surface will be waived, surface use will be waived or not. They didn't fill that out. We didn't attach that. I had in our contract as proposed, there were no reservations. What came back to us was they added a provision that says, see the form for the deed attached, and they attached the deed. Well, I didn't see, I wasn't aware of that change where they added the language, and I wasn't aware of the deed that they attached.
Okay.
So, the question of whether we had a meeting of minds, it was probably the document that was in front of the judge to sign after the court approved it. It's the one that's been signed by the judge. I feel fairly confident we could get out of it. The question really to you is, what are minerals worth, and was it your understanding that you were paying the amount that we agreed to pay because we were getting the minerals with it? Gas is worth very little, and I don't know of any ongoing oil plays in the south end of the county. So I don't know that it's worth a whole heck of a lot, but it is forever, and you never know what's going to change.
Let me call Kevin Mills, because he and I are the ones that kind of make
Okay,
this deal.
fine
Kevin's a
with me.
man for them, and we did not discuss that up front. It may be that the people who own that kept the mineral rights to it.
Yeah, I've got their deed, and I don't believe there's a reservation in their
Okay.
deed, right? I
Okay.
don't.
But
I
I'll
looked at their deed.
call Kevin and
Okay,
ask
we'll
him
do that.
about it. It may be that their attorney just put that in there.
Yeah,
But we
and
did
it's,
not discuss that at all.
okay, well, it would be, and I should have raised the issue, but when I drafted the contract and it went out the door, and it was the last one that I saw, it said we were getting the minerals, so I didn't know there was an issue to raise, and so I.
And that's what I'm gonna tell him when I talk to him. I thought
Okay,
we were getting the
but I just know that I can't talk to him if he's represented by an attorney, so that's why the
Yeah.
contract indicates who their attorney is. It's in-house counsel with CenterPoint. That's who I called and left a voicemail with this morning at 8:30.
But I will talk to him.
Okay, well then let me know what you find out.
Okay.
And if any member has strong feelings one way or the other, you're welcome to call me in my office. You don't have to do anything.
There is gas production and oil production not far from that property, probably within 2 miles straight across.
Yeah, and the question is the price that we're willing to pay, does that include minerals? Or does it, in your brain, should there be a reduction because we're not getting minerals? Should we, fight to the death and say, well, at the very least, we want 50% of the minerals, we'll live as long as we get a surface waiver. There's any number of those issues that we would have addressed had I known they were requesting that. I just did not know that, and I should have.
I'll definitely try to renegotiate that if we can.
Okay.
And I think from our standpoint, the surface waiver is the key issue.
Yeah,
Um,
sure.
That's probably the bigger of the two
Yeah.
aspects of it.
Yeah, because if they came in with a five acre pad, we'd be giving up 25% of what we purchased.
Yeah.
Yeah, and a lot of drill sites are smaller than that. A couple acres is pretty typical.
Yeah.
I've seen them up to 5. So definitely significant consideration and use of the property.
And Kevin's the one that sent me the email with the proposed deed as an attachment. And I believe there was a second email where there was a change made to the county that was named in the deed. For whatever reason, I didn't see the deed in either one of those emails, so.
Okay.
Just as the question, say they did reserve the mineral rights, do they then have the right to put in a pad?
Well, not if they waive the surface use, but they
But
do.
it has
But they
to be
do.
waived.
The mineral state is a dominant state. You as a mineral owner get to use the surface
Okay, that's
for
what I
any
wanted to know.
reasonable purpose related to your minerals. Yeah, it's gotta be reasonable use, but typically, you're the dominant state owner. It's a real risk if you buy a piece of property and you don't get the minerals and you don't get a surface waiver. If, one of the issues, and I'll pose this to you, and so you're aware of it, if we thought that there were other owners of the minerals besides Centerpoint, getting Centerpoint to do a waiver of the surface doesn't do us much good.
Right.
Because it's the people before Centerpoint that would have the minerals that we would need the surface waiver from. I'm fairly confident that an operator's probably not gonna put the well on the 19-acre tract anyway. You usually put it on the 100 or the 200 or the 500-acre tract where you're gonna put it. You can pull in gas, you can pull 640 acres.
Yeah.
So, I doubt it's gonna happen anyway, but it is a risk. But looking at the information that we have, it appears to me that the last leases were signed by the people that conveyed the property to Centerpoint. So, oil and gas companies hire attorneys to do a title opinion before they go writing a check to somebody. They wanna know that they got the minerals.
Mm.
So, by deduction, it appears that Centerpoint has the minerals, and that they could do a surface waiver that would be effective.
All right.
Okay. Mr. Walker, you expressed some concerns to me that were legitimate concerns on your part, and a couple of things I hadn't thought about. So we thought it best to call this workshop to share some of those concerns or ideas and thoughts.
After we made the decision to buy this property, I started hearing different ideas floated around for the potential use of the property. And then the secondary part of it is, okay, if we move the maintenance barn to this property, then what happens to the existing site in Stoneham? And there's enough potential uses there, a lot of things the county does, a lot of needs they have that I'm not aware of. Thought it'd be worthwhile to have everybody sit down and actually think about it, and talk about it, before we get too far down the road on this. It's a 19-acre tract. We, for road and bridge, we've expressed that, half of that, 9 acres, basically, would be more than sufficient for the new barn. So that leaves the other half of the property available for other uses. What's the highest and best use? What, people have talked about, we've talked about leasing it out, we've talked about we can just go ahead and sell it. What other, we've had some discussion about EMS, are they gonna move up there with us, the dump, different things. Felt like it was just worthwhile to talk about it and see, what the conversation, really needs to be, where we need to kind of focus our attention. Commissioner Dobianski has set up a meeting for us for tomorrow with Magellan Pipeline, talk about potential them leasing the site or a portion of it for the pipeline they're gonna be building. There's a lot of moving parts to this, but I felt like it was worth a group discussion at least as to, what thoughts y'all might have, or what kind of requests you may have seen from other folks, within the county. thought we ought to bring it up for discussion.
Sure.
Well-
I'm sorry, 9 of the 19 is kind of what you're thinking is an appropriate amount for R and B?
And that's based on what we have up at Iowa, which is a good layout, good site. That's sufficient for us. Currently, we've got about 3 acres down in Stoneham, so anything extra, they can get there, definitely make life easier. We're just shoehorned in down there. So, and I haven't looked at exactly how this breaks out, even, tried to identify which portion of the property we would want. Like, that kind of depends on what other uses, might be appropriate for it. The property right now has public water. There is a septic system for the house that's on there in the middle of the property, which CenterPoint tells us they had to redo when they took over the property. There is power available, so it's pretty well set up, ready to go for a lot of things. But it's not, the septic system in particular, it's sized for a house, basically, that CenterPoint was using for a little bit of office space. That may not be adequate, even for the maintenance barn. I'm gonna get that information from CenterPoint of what they did have done and see if they have the economic capacities, find out what's even possible there. And then the house itself, could use some maintenance. There's some things that ought to be done to it, but whether we spend money on maintenance of it now, or who spends the money on maintenance of it, kind of depends on what's that gonna be used for. Certain members of my staff would love to see that become a new road and bridge office. I don't think that's probably the best plan.
Why is that?
What's that?
Why is that?
Well, for one thing, the co-location of road and bridge, environmental group, and 911 addressing works very well for the public. They come in and get all their permits, at one spot.
Oh, I'm sorry, you're talking about your office relocating there?
Yeah, they,
Okay.
half in jest, they were proposing that, we should open a branch office for road and bridge at this location, because it's more convenient to their houses. Not necessarily the best basis for a decision, but I think as far as serving the public, it makes more sense for road and bridge office space to stay here, in Anderson. So I'm not proposing to do that, but then, if not that, then what do we do with that building? I know that, the EMS was brought up, they've got a trailer down there in Stoneham now. They might be, able to use that house. It's they have people staying on site, 24 hours a day now, so they have, shower facilities, restrooms, and cooking facilities and everything, which, this house has already. So it might
And
be
what
something-
size is the house?
What's that?
What size is it?
I think it's about 1,400 square feet.
Yeah,
Okay.
living area, probably, maybe a little more.
So it's nothing huge.
It's not huge, but it's not tiny. It's 2 bedrooms, a large den area, and a large kitchen breakfast area. 1 bathroom in the house, and then there was another bathroom added by CenterPoint in the garage area, 2-car garage. So it's more an operation like the EMS. I think it would be plenty big, if not bigger. They're operating out of a travel trailer now, basically.
Would it work as a combination office? I heard you say it has a garage. It has a garage with a restroom in the garage?
Yes. Yeah, because there are 2 separate restrooms, it should be split and used for 2 different purposes.
Mm-hmm.
If EMS were to use it, and, I haven't talked to them about it, but the kitchen area would be attractive to them,
Mm-hmm.
and then some sleeping space, which the bedrooms, would be appropriate for that.
Well,
there
we're
might
meeting
be-
with them today. It could be something, we could speak to them about. The other thing I was thinking, if you, cause, environmental has what there? They have a little building over in Stone.
It's a
Garbage.
Yeah.
Yeah, it's a little down the street though from y'all, isn't it?
Yeah, the environmental group has a dump site in Stoneham with a, ticket takers booth basically, there. And again, what we do with that starts to affect what we're gonna do with the Stoneham property.
Mhm.
Um,
Cause it's all one property, right? And Stoneham, they're
Right.
located on Road and Bridge property, right?
Yes, the EMS, the dump site, and our, the road and bridge operation is all located on one piece of property.
Mhm.
I haven't seen the documents yet, but I'm told that the Stoneham sisters granted the county a strip of property that was a private road that ran through there that has reversionary clauses in it, that if it's no longer used for county purposes, it would go back to them or their heirs. And again, I am told, I haven't seen the maps or anything, but that actually runs through the shop building. Which would, if that went away, would certainly diminish the value of that property for anyone else that wanted to use it if the city were made to just try and sell it. So it may be to our advantage to keep it.
And what I hear you say is we have to go through their property to get to the property.
Well, again, as I understand, that area had some private roads through the property, back in the old days, that because they're private roads, they belong to the Stoneham sisters.
Mhm.
They granted that property to the county, but they had a reversionary clause on it. If the county no longer used it, it would go back to them, or in this case, their heirs, which could create a significant issue if the decision were made just to sell the property. Now, not that, we couldn't go and acquire those rights on a permanent basis if we wanted to sell it, but it's definitely a consideration in the future of that property.
So is it diminishing the size of the property if it reverts back? Is that what you're saying?
Yeah, there's a
Yeah.
strip, road right of way width, 50 or 60 feet, that runs off of the spur through the middle of that property is what I'm told, and through the shop building. So obviously, if we're going to try and sell it to somebody that's interested in the use of that shop building, we need to acquire permanent rights to that to be able to sell it and not lose that value. So there's some issues down there, and it may turn out that maybe it makes more sense just to keep it for the county's own use and find useful things to do with it. But if the decision is made to sell it, we'll get some legal work to do, to maximize the value of that. And then, of course, if we do sell it, then we'll have to work out some other arrangements with the EMS and then a different location for the dump site. That all plays into what gets done on this property too. EMS is pretty simple, not really a major issue. In this case, if they were to take over that building, it's got its own water, it's got its own septic, it's got its own power, we wouldn't have any of the issues. Currently, they're on our septic system, they're on our water, they have their own electric meter. Essentially, the county is paying for their other utilities. In this case, that could be separated, and they would be a standalone, they just pay for whatever utilities they use.
Now, as far as the barn, you say you didn't see an immediate, what's the timeline if you were to purchase the property and us occupying it?
Well, assuming the purchase goes through and the mineral issue doesn't blow up the whole deal, I went ahead and requested money in this coming year's budget to construct a new barn on this site. So that may be October
but in your talks tomorrow with Magellan, say if Magellan wanted
Yeah,
to
Magellan,
lease the property.
I don't know if you talked to the commissioner about how much the property that they're interested in.
We'll find that out tomorrow when we meet with the contractor, because I have not talked to the contractor. They actually
They called me.
Mr.
Okay.
Faust.
Well, my question is, if it's profitable for the county for them to lease the entire thing in order to recoup the money that was spent on it, then your timeline could change a little? Are you flexible?
You know, certainly, if we have an opportunity to generate a significant amount of revenue for the county that would pay for this property or significantly reduce the cost of it, we can live on what we've got for another year or so. What Magellan is telling me is that late this summer, they're gonna start construction, and their project should be finished in less than a year. So it might be a matter of delaying any action on the site
Yeah.
for a year. Not, certainly not the end of the world.
But it's also my impression they're not needing the full 19 acres.
Yeah.
Because they've already done an on-site, and almost where the paper folds, I'm thinking, you know, they'd be looking at that eastern portion, and that western portion would still be available to us in the event we wanted to start building a barn or relocating,
Okay.
those kind of things. So
And if
they're
that's-
not looking at it for the full 19, so my understanding is today.
And if that's correct, then certainly, we can pursue both options. Get the revenue we can out of it and go ahead and move forward with some construction on the other side. I think, again, out of the two portions, it makes sense to me that they would be more interested in the eastern half. It's a larger laydown area. a little more
That'd be this
compact.
portion here. So this is the part that they're probably pretty much looking at.
It's level also, it's,
So it's the other way around.
yeah, it's a more level ground.
Right.
As far as handling that pipe, it'd be a lot easier if they're gonna move pipe in there.
John C., are you gonna join that group tomorrow?
Which group would that be?
That is the on-site of 2445 at 10 a.m.
To have a juvenile docket starts at 9 and probably run till 11 or 12.
So the answer is no.
The answer is not, I don't think so.
Okay. Do you, and not David, or Commissioner, you might have a feel, but do any of us have a feel of what that land might be worth in a lease or a rental agreement?
Well, and that's what I was reading. I wasn't asleep, I was reading.
I didn't suggest that.
There are two ways to lease. One is a public auction and one is through sealed bid. And you gotta do notice. The idea being, if the county owns a piece of property, if you were going to sell it, let's just talk about that for a second, you would have to justify to the taxpayer that you got the most amount of money for the property. Therefore, an auction or sealed bids would be required. Same thing for a lease. You may have some folks that are interested in it. You may know that that's probably the best that you can, you may know that what they're willing to pay or what you think is the right amount based upon information that you've obtained on your own is the appropriate amount for a lease. You still gotta subject it to an auction or to sealed bid. Now, if you do sealed bid, you gotta do an appraisal.
However,
Yes.
if it's our intention to lease it to them so that they are able to make it a point of drop for their materials so we can collect their sales tax, does that change the scenario?
Doesn't change that you still gotta have an auction.
We're not looking to sell it.
I know,
We're-
I'm reading you the
Said
section.
lease is the same as selling.
Commissioners Court of a County by order to enter the minutes may appoint a commissioner to sell or lease property owned by the county. The sale or lease must be made at a public auction held in accordance with this section unless the chapter provides otherwise, and the other provides otherwise is through sealed bid. And that's sale or lease. And so I hear what you're saying. Probably, you can take that into account and you could put in your auction or in your notice. The likelihood nobody else gonna show up to lease, all right? So nobody else gonna show up at your auction. But if they do, you could consider that as an additional term and what you want, as far as from the people who are bidding. But there's not, to my knowledge, there's not a way around this, and it's because it's to avoid a deal where you give it to a buddy or a friend or somebody who's offering a kickback and you do it for $1. This is to get the taxpayer the maximum amount you can on a lease or a sale.
So the auction would be
I think I'd rather see you do the auction because likely no one will show up but the folks you're talking to, and if you do the sealed bid, you gotta have an appraisal.
You have to have an appraisal with the sealed bid? I thought it was for either or.
No, I don't think so. No, the 263.001 talks about the auction without an appraisal. 263.007 says, before selling the property under this section, the Commissioner's Court shall obtain an appraisal of the property's fair market value.
What's that number again on that code?
Sure, 263.001 and 263.007.
And I assume the appraisal is only applicable if we're looking at selling the property, correct?
No, it says, the Commissioner's Court may adopt a procedure by which the county may sell or lease through a sealed bid or sealed proposal procedure any real property, including space in a building owned by the county.
John, at an auction,
How do you do an appraisal if you're just gonna lease the property?
You'll have to ask an appraiser to do a lease appraisal. Yes,
can you start the auction with a minimum bid?
can you? Yeah,
yeah.
yeah, what you would do is authorize one commissioner, likely in this case, Commissioner Dobianski, to conduct the auction. And he and I would talk about it, but yeah, you could put a minimum bid on it.
So if EMS were to lease the building from the county, the same process has to happen?
If EMS, it's not us, yeah, if it's not us,
Are we
if it's a
EMS?
no, I mean, if the county had EMS, if it was a county entity, if you're saying it's not a county entity being St. Joe's or CHI, if it is a lease, then yes. If you're leasing them the property, then yes.
Are we actually leasing that site?
No,
currently?
no, it's all built into our,
'Cause I think
Well, I
essentially
think
it
part
was
of
to
the-
defray the cost of having them bring that service in.
Well, I think part of the deal was, and Ms. Walker may know, is that the county paid $300,000 for that ambulance. And in doing so, we also agreed to supply a place for them to have it.
yeah, we purchased that ambulance. And, all of that happened in 2008. But everything now fell up under the 1115 waiver as far as the operations. So, that's a question for the county attorney.
I'm gonna tell you at the end of the day, there's probably a little downside. The problem though, of course, is if we're asking them to bid, if we're asking, and this is related to the agenda item, so I think we're good. If we're asking them to bid what they will pay us for the lease, and it is provision of medical services with a very small lease, we'll have to leave that in the commissioner's hands when he conducts the auction. The best I can figure. I mean, they're, of course, if we were paying for it, we're not paying them. I was thinking about the discretionary exemption that exists for emergency medical services. There is a discretionary exemption, I think, for that. I don't know a way around it. I mean, I'll be happy to look to see if there's any AG opinions that speak to that. But it seems to me that you have to consider all of the things that they're providing as part of the payment, not just money.
Mm-hmm.
And I would assume if you're gonna go through the lease process, we could designate separate parcels, a portion with the house, an acre or so of the land, and then the larger piece for the laydown yard and have interest for different parties. I would also think that in the evaluation, or actually in the lease documents, you can write into it the estimates of sales tax generated by the lessee's use of the property. It would be obviously a major factor in deciding who made the most sense for us to lease to. I'm a little concerned that 249 coming in the not too distant future that will be construction yards. And then the high-speed rail folks, they've been on acquired property and doing things. It would be pretty embarrassing for the county to have an agent for the high-speed rail come in and lease property from us that we've been fighting against them. Wouldn't look good in our page.
Well, you can reject all bids.
Yeah.
So I think we need to be a little bit careful.
Okay.
I don't know how you avoid getting tangled in with an agent or someone else that you don't really want to do business with, but I'm sure our esteemed attorney can figure that out.
Yeah, well, I understand, just the point being is that you're trying to get the taxpayer the most bang for the buck, which obviously makes sense to all of us.
Additionally, we have,
So I'm not running out of time.
we have someone who wants to buy half of that property also.
Say again?
We have a buyer that wants to buy half of it also. They pay us half of what we pay for it. So that's on the table.
All right. Maybe we'll get some of our questions and thoughts answered a little more effectively tomorrow, or
Yeah.
generate some more questions tomorrow that we can bring it back.
Yeah.
Yeah, I think we'll have more information after the meeting tomorrow.
Okay.
It sounds to me like we need to approach DMS and start a conversation with them.
The Commissioner, I can talk to them at 1 o'clock today, 1 o'clock today.
Okay.
And then, of course, our
I'll be there.
start looking into, some of these other issues with home property and whatnot.
Yeah, do you have them? Can you go?
I have been told,
We may need to understand how
Well, see if you
where
can,
we
if not,
stand.
then I'll figure out how to get them.
That's
See if
great.
you can get your hands on
We don't want to open a can of worms there.
them. Oh, yeah. I have to research to find stuff. If it's before 67.
Yeah, we got one
you gotta
after
open
this
every
one.
before the
How'd you-
grant-
No, it's EMS.
So it's like.
No, it's not posted.
Did you meet at 9 in the morning? David? Harry?
And if he's coming, then that's two of us
Commissioner?
already.
Yeah.
Versus 10? Okay.
Yeah.
But I'm
To
gonna,
bring
if
this
you're in
back.
agreement, I'm gonna ask them if they can meet at 9 versus 10.
Okay.
But I know that doesn't help our county attorney, but
I'm sorry,
that's all right, we're leaving you out of this. You can watch it on the tape.
sorry, it was a voice in my
Okay.
ear. I may just be hearing voice out there.
All right, and I'll let you know on that. There's no further discussion. Agenda item number
We
3.
need to look at our arrangements with EMS.
Move to adjourn.
Second. Approach them so we
Commissioner
know
Mallett,
what our rights are.
there's a motion before the court to adjourn, seconded by Commissioner Dobianski. All in favor say aye.
Aye.
Opposed? Motion carries.
David,